SJC-13442, Commonwealth versus Jason Estabrook.
Attorney Crouch.
Good morning, Your Honors, and may it please the Court, Andrew Crouch on behalf of Jason Estabrook, who appeals from convictions out of the Middlesex County Superior Court. I'd like to begin today by addressing the motion to suppress issue. When Detective Frost led Mr. Estabrook into the Sally Port of the Billerica Police Department, a lot of history followed the two of them in there. And that history is relevant to this Court's determination of whether or not a custodial interrogation occurred or its functional equivalent. Specifically, these two had met on several occasions previously. Detective Frost had interviewed Mr. Estabrook on several occasions. An objective observer would be aware of this and an additional following facts. At that point, Mr. Estabrook had been interviewed several times with some pointed questions about his involvement in the Billerica homicide. And at the end of an interview where Mr. Estabrook had invoked his right to counsel, Detective Frost at the hearing had testified, that this case will continue. So this was not an investigation that was going to go away. What we also know at that crucial time is that Mr. Estabrook has just been arrested. He is within minutes supposed to be transported to court for his arraignment for first-degree murder. And we know that the Detective Frost has several key pieces of information. In fact, really the only evidence in the case that he is yet to confront Mr. Estabrook with. And as the motion judge found in this case, this was going to be his last opportunity to do so. And it is in this context that an objective observer can review these facts and make a determination as to whether or not the questions that follow, or the communications that followed between the two of them were sufficient to constitute, we're likely to elicit an incriminating response. And we suggest, indeed, that was the case. This conversation.
Are you contending that the incriminating responses were elicited during the Sally Port conversation, or that they were elicited during the subsequent, let's say, formal interview?
We say both, and certainly the second one I think is no one will question.
But what were the incriminating responses in the Sally Port?
So when they move into the Sally Port, as I said, we have that history that we have to keep in consideration, and in that context, the first words essentially out of Mr. Estabrook's mouth are about his cousin, Mr. Bradley. He wants to know about Mr. Bradley. It's not that he is prompted by Detective Frost, so he starts asking immediately, has Adam been arrested?
Is that incriminatory?
I think in this context it is, and I would suggest this.
All right, but that wouldn't be suppressed under your theory, correct?
It would be. It would.
There was nothing that the Frost did not say
in terms
anything.
In terms of a first statement, no. I think that that's fair. That statement would not be because he
didn't say anything.
Because Detective Frost hadn't done anything yet. Is what follows. Your Honor is correct. But keep in mind, and I think what's important is to keep in mind the context of what the Commonwealth's evidence is at this point. It's simply, essentially, the Salem, we have Salem hospital records that have some incriminating statements in there, and the video, but otherwise we don't have CSLI, we don't have cell phone data, we don't have DNA, fingerprints, any of the other, no ID. This is, he has been arrested essentially on what has happened in Salem. So with that evidence in mind, we have Mr. Estabrook saying immediately, talking about Mr. Bradley.
Well, we don't consider what the police officer had in mind, right? It's what objectively is portrayed to the defendant, not what the police do or don't have subjectively in mind. Correct? I think that this is one of the key issues in the case, and I would say that the motion judge found that the police officer's intent was irrelevant, and that is not the state of the law. While it is not a primary consideration, it is certainly a secondary consideration. It is part of the calculus in making determination here, because it goes into the question of what the office, essentially what the police officers knew in making a determination in that objective observer consideration. The judge finds that the statements viewed by a reasonable person in the defense circumstances, whether those would be interrogation. Is that the proper statement? The judge says that looks to see whether or not the interview was, whether or not the statements portrayed by the police officer would be viewed by a reasonable person in the defendant's circumstances as interrogation. Is that a misstatement of the law?
That is the correct statement of the law.
Okay.
But also the judge's determination very specifically says the police officer's intent is irrelevant, and the case law doesn't support that. So to continue with Justice Wolohojian, so we have that first statement. He's referencing Adam Bradley. So then the next question, and the answer to that question should be no, he has not been arrested. Instead, it is that no. The answer is no, but instead, he has not been charged, but he has been interviewed numerous times.
All right, so you're not contending that the detective should have just said, I can't answer any questions at all. You're saying that his answer went too far?
And provided additional information, essentially breadcrumbs to entice Mr. Estabrook.
So this is helpful to me. So is it your position that the officer may answer a defendant's question but may not go beyond it?
I think in terms of providing factual information, we obviously have cases like Chadwick that sort of provide some guidance here. But in terms of this context, the answer to that question is no. When you start, if there's other information that is not in any way designed to elicit any kind of incriminating response, that may not be particularly relevant. But where that does provide additional breadcrumbs, as I say here, to entice, we know, the objective observer knows that Mr. Estabrook is concerned about Mr. Bradley, is concerned about what role he is playing with the government at this point. He has been the subject of multiple conversations previously between Detective Frost and Mr. Estabrook.
Okay, so I just want to make sure that I understand that what you're asking us to evaluate is the quantum of difference between an answer that was substantive, that would be no, in other words, answer his question, he hasn't been arrested, and the additional piece of information that he had been interviewed.
Yes, the additional piece of information that he has
And
been...
so we're only looking at that little piece of additional information
For this
argument.
For this first question. So,
Okay.
because there are subsequent questions that I think we start to build in terms of the concerns. So now, the answer is no, he's not been arrested. Mr. Estabrook, that would probably, one would assume, suffice to satisfy him, he's not been arrested. But then you provide the additional information, he has been interviewed numerous times. Why has he been interviewed numerous times? So then he, of course, responds with the inevitable follow-up question, has he turned state? Is he cooperating?
So here, I mean, we know that this was already a question on the defendant's mind before this exchange. So how do you manage to establish any kind of causation between Frost's response to this first question and the defendant's decision to make further statements?
Certainly. So the standard we're looking at here is that objective assessment, the objective observer assessment, in trying to determine whether or not an objective observer would infer that the police conduct was designed to elicit an incriminating response, keeping in mind what Detective Frost knows. Detective Frost knows all of the things that I've said and more about when they move into the Sally port. He knows that providing this additional piece of information that he's been interviewed numerous times is going to feed into his already stated concern about Mr. Bradley. Because as we know, the evidence against Mr. Estabrook at this point, even upon his arrest, is not particularly strong. It's pretty limited evidence. It's far more limited than against any of the other co-defendants or in other cases we usually see here. So it is indeed the statements that he is making here, and I would contend indeed these are statements that, while they don't have to be used by the Commonwealth at trial, if Mr. Estabrook clams up at this point and says nothing further than what he says in the Sally port, I anticipate the Commonwealth would have been using this sort of evidence at trial because of the paucity of the evidence at this point. But as we build here in this conversation, and it's not a lengthy conversation, but it's enough to cause, the question is we're trying to objectively look at whether or not what Detective Frost is saying is enticing Mr. Estabrook to eventually waive his Miranda rights and acts as a coercive act. And I would suggest that, if it was just a simple statement, no, he hasn't been arrested, we probably wouldn't be here with this argument today. But as he continues to provide additional information, additional breadcrumbs, sort of enticing Mr. Estabrook in, and then we move on to additional, his additional statements there. He says, asked whether, Adam had turned state. The answer to this question is no. But indeed, that's not what the response is. The response is that, the defendant would have to be Mirandized for the detective to tell him what Bradley had stated. And then we move into the final part, which is, I cannot
Why
believe...
isn't that a correct response?
It is a correct response, but then it's followed by the next statement, which is that I can't believe Adam turned state, which is not a statement that requires any sort of a response. It's not a question. But then he says, I have a videotape of the interview, and I can show it to you if you waive your Miranda rights. This is building, this has now provided Mr. Estabrook with information he did not previously have, information that is feeding upon his primary area of concern, which is that his cousin, his best friend, has now turned on him. And accordingly, I would suggest that these are indeed incriminating statements. As I said, in the context of what follows, the next 3 hours, no, they pale in comparison to what he then unloads onto Detective Frost and the police department after that.
I understand your comparison to Chadwick in terms of the response about the video, but what's your best case for the proposition that we have to look at all the circumstances, and Frost only makes that statement after he's explicitly said to the defendant, we can't talk about this until I've Mirandized you? What's your best case for the fact that we can rule in your favor, notwithstanding that express statement?
Certainly. We have, the sort of challenge here is that we have, some cases that don't, I think Chadwick is one, that is helpful in this particular regard. Just a moment here. Chadwick is helpful. Rubio to a lesser extent because it's more showing the individual the situation. I think it's maybe Clark C that we look at as well is helpful. These are all cases where, especially Clark C and Chadwick, are cases where the court or the officer is maybe providing some factual information, but is also providing it in a way that causes the defendant to, it works as a coercive act or as something that is designed to elicit an incriminating response. So I would suggest that those are probably the cases that we look at that are the most serious. But I think the other important thing to note here is that even if this court were to find that these statements were not incriminating, that doesn't end the inquiry. We obviously have to move on to whether or not these actions coerced the defendant to give up his Miranda rights in the subsequent interview as well. And those are another area that this court has to consider. Specifically along those lines, when we start looking at the conversation that follows, we would suggest, here, based upon the information that Detective Frost had, putting it into the context of the objective observer test, an individual who is an objective observer in this circumstance would believe that the statements made by, in response to the questions and statements made by Mr. Estabrook would indeed have been tantalizing, would have enticed him to waive his Miranda rights, and would indeed have been coercive. I'm happy to address any other questions the court has on that particular issue.
Well, do you want to respond to the cat out of the bag argument?
Yes, that was where I was going to pivot to next. So in terms of the cat out of the bag issue, I think one of the primary things to keep in mind is the cases that the Commonwealth cites here are in the context of a non-coercive situation. When we're starting to talk about those two standards that apply, cat out of the bag very specifically does not apply in a situation where there is coercion. So I think that while the case law on this point has been not perhaps as clear as we would like, I think the Commonwealth does this court and myself a favor in citing to the case, the appeals court case from October of last year, Commonwealth versus Hand, which was released 2 months after we put forward our brief in this case. Hand is a very helpful case. It goes through the history of these issues. But Hand the Commonwealth relies very heavily on Larkin for its propositions that, essentially, look, I think they even said the line in their brief was, the cat did not even peek out of the bag. I would suggest the cat's not relevant here. And the reason that is Larkin is not relevant because the interrogation, without the benefit of Miranda warnings, while it is in itself improper, Hand says specifically, the second method of overcoming the presumed taint, showing that the cat out of the bag, is not a valid manner of overcoming the taint of a coerced statement as a matter of federal constitutional law. And it's citing, it's also citing, cases like Meehan and Mankey here. But I think that it does a good job of explaining, first of all, that the cat out of the bag situation is not relevant when we are talking about a coerced statement. Because the cat, just simply because an individual later on, believes that he may have said something earlier and his situation is hopeless, that doesn't overcome a coercive act designed.
So what you're essentially saying is the coercion here did not take the form of the cat being out of the bag, and
yes.
And so, what can you give your best argument for what the coercion here was?
Sure. So again, looking through that objective lens, we go back through the entire history of what Detective Frost knew when he moves into that room.
When we look at coercion, do we have to look at it? The coercion is what happens in the Sally Port, correct? The course of conduct is a Sally Port discussion, correct?
I'm sorry.
The coercive conduct is a Sally Port.
Yes.
Okay.
Yes, Your Honor.
Is it fair to characterize that the defendant is driving the train? He's the one asking for information from the police officer, correct? And there's no incriminating statements made by the defendant during that Sally Port interaction, correct?
No, as I argued earlier, I believe the statements were incriminating. As Justice Wolohojian noted, perhaps that first one is not incriminating because, or certainly not enticed by the officer. But I think keeping in mind the context of the paucity of the evidence that the Commonwealth has upon arrest here, that evidence is certainly evidence that I think would come in at trial had he clammed up at that point and said absolutely nothing further. Because otherwise there's a lack of evidence. We have some Salem Hospital, the records of the tea kettle. We have the video, which the individual, the victim who survives, is unable to specifically ID the defendant.
The tea kettle is pretty damning, isn't it?
The tea kettle is I would concede is the strongest evidence here. But that's what it has. It's going to go to trial simply with the tea kettle
And an ID.
Well, the ID is Ryan the victim is unable to ID Mr. Estabrook. He has a description. That description, at least in the video, there is an argument as to whether or not the color of the stripe or what it may be. It's arguable. But certainly this is not the level of evidence
And
that
I don't
we
want to
get.
distract you. So basically, you're saying what happened in the Sally Port was coercive, and we have to look at that in the Miranda context.
Yes, Your Honor, and it informs the discussion of what comes on later. And this is an unusual case. We don't see a lot of cases like this. The case law on this has not always been as clear as we would like. But I would suggest this is that sort of matter.
Is it determinative of the Miranda issue? What happened in the Sally Port?
I think it is. Is it?
So
Yeah.
I guess it's stated differently. If we disagree with you that what happened in the Sally Port was coercive, does your argument about the subsequent Miranda go away?
I think if, in terms of that's certainly a complicated question. In terms of it certainly at a minimum weakens it. Whether or not it gets rid of the entire argument, I'd have to provide more thought on that. But I think you still have to look at the voluntariness overall. There's the secondary voluntariness issue. So I guess the answer would be no, it doesn't fully obviate it, but it obviously would substantially weaken it.
What did he say in the Sally Port that he had not expressed previously to a police officer?
Well, previously he had denied any involvement. He had denied Adams' involvement. At that point,
But hadn't he already inquired whether anyone had turned state? Hadn't he also previously inquired about whether his cousin had been arrested or interrogated?
Frankly, I don't recall whether or not he had
No?
asked those specific questions. I think he had denied, certainly Detective Frost had kept saying in both of the interviews, your name keeps coming up, your name keeps coming up. And they talked about, they reference Adam Bradley, but at this point, and as the motion judge here finds, I think significantly, this information is not information that had yet been shared with Mr. Estabrook. Indeed, this was Detective Frost's last opportunity to confront him with it. He was supposed to be on a bus to court within mere minutes, and essentially this was the last crack at it with the information that had not, while previously, Adam Bradley had stated this to Detective Frost, Detective Frost had not yet confronted Mr. Estabrook with it.
Okay,
Thank you.
thank you. Attorney Charles.
Good morning, Your Honors. Assistant District Attorney Jamie Michael Charles from Middlesex on behalf of the Commonwealth. I was also one of the trial attorneys in this case, along with ADA Dave Solid, who's seated at counsel table with me. I'm happy to address some questions on the functional equivalence argument, but I would like to first turn to my brother's position on Larkin and the cat out of the bag argument. It seems to me that my brother is suggesting, even if we're interpreting this interaction in the light most favorable to his argument, that if the police confront a defendant or alert a defendant to the fact that they have incriminating evidence against him, that renders a subsequent Miranda waiver involuntary. And I would suggest that Larkin suggests the exact opposite, right? If we look at the facts of Larkin, the police sit down with the defendant who's incarcerated on unrelated charges, and they essentially say to him, listen, we have unimpeachable evidence of your guilt, and if you waive Miranda and give us a statement, we'll tell you what that evidence is. So that's apples to apples with the most favorable interpretation of what happened in this case. And the court in Larkin explicitly said, where the defendant didn't incriminate himself in response to that information before he waived Miranda, the cat was not out of the bag. So they applied the cat out of the bag analysis. If you look at Larkin, the waiver of Miranda happened minutes after the defendant was confronted with that salacious piece of information. So
Is Hand any different?
I'm sorry.
Is Hand any different?
I don't believe that Hand is different. And I think Hand, in fact, the reason the Commonwealth cited Hand is it essentially reiterates this idea that the Commonwealth doesn't have to satisfy both tests, right? There will be circumstances where a defendant doesn't make incriminating statements, but we look to the other test for some reason. And I would say let me reclarify. In the past, this court has suggested that there might be a case where in the absence of a cat out of the bag situation, you would still look to the temporal proximity. I think it's fair to say that the court has suggested that that would have to be a pretty egregious case. If you look at the footnote in Larkin, I think it's footnote 9, it disavows what was previously said in Prater and Smith, those prior statements that might have suggested that the Commonwealth has to satisfy both prongs of this test, assuming you find the functional equivalent. And again, the Commonwealth doesn't concede that that's what happened here. And Hand, again, sort of reiterates, at least the appeals courts, obviously they don't speak for you, but it reiterates the appeals court's interpretation of what this court said in Larkin and how this court analyzed the issue in Torres in 2014, that if the Commonwealth satisfies either one of these, then there is no need to conclude that the subsequent Mirandized statement needs to be suppressed. So here I would say we're really on par with Larkin. At the most favorable reading to the defendant is that then Detective Lieutenant Frost intimated that maybe Adam Bradley had said some things that were adverse to his interests, but there had been no explicit mention of what had actually been said. And if you look at the analysis, it's really, did the defendant feel defeated? Did he feel that, I think the language used is repetition or amplification of earlier statements? Again, the Commonwealth's position is there were no statements that were incriminating. But certainly there was nothing that gave up the store, so to speak.
But I mean, I have trouble with that part of your argument because it's very clear from the moment while he's being booked, he's like, my cousin has turned state, and he, then there's the subsequent meetings, and he knows that after the first answer of Frost, that his cousin has been repeatedly talked to, but not arrested. So, and he has at this point been arrested for a first-degree murder. So the clear implication is that a reasonable person would assume that his cousin has given him up. And then the detective further reveals that not only all that which the defendant had essentially presumed, but also they have it on video. And that is additional information. They basically, it's, in other words, the detective is saying, we have you dead to rights. We have your cousin on video saying that you did this. So, and I don't see how it's not, his response to that is not when he says, I didn't believe, when his statement, I wouldn't believe that my cousin would have, turned against me or whatever, however he put it.
So the Commonwealth feels that that's a strained view of the import of the statements, but a couple points. Number one, as I alluded in a couple footnotes in my brief, no evidence was elicited at the hearing that Detective Lieutenant Frost had been alerted to the specific statements that Mr. Estabrook made to a completely different officer the night before when he was not at the station. So Lieutenant Ronstock, who did the booking, is the officer who testified to the statements Justice Wolahojian alluded to when my brother was talking, which is that Mr. Estabrook had said, I think it's something to the effect of, no matter what Adam said, I didn't do anything. There was no evidence presented on direct or cross of either Lieutenant Ronstock or Detective Lieutenant Frost that those statements had been relayed to Detective Lieutenant Frost, who only showed up the following morning for the fingerprinting. Secondly, if we're talking about the chronology of what happened in the Sally Port, the statements the defendant made, I would submit, again, viewing things in a light that's more favorable to the defendant, occurred before what the interaction even came close to turning into the functional equivalent, right? Unless this court wants to say that Detective Lieutenant Frost's statement, he's been interviewed, is so coercive that it induced, I don't know how this court can say that. I think it's a pretty vanilla statement to tell somebody that someone's been interviewed with no additional information. So in response to that statement, Mr. Estabrook says, did Adam turn state, right? So I would submit at that point, even in a light most favorable to the defendant, there hasn't been the functional equivalent of interrogation yet. And to that, all Detective Lieutenant Frost says is, I'm not going to talk to you without Miranda.
But so the question is, the part of your argument that I was taking issue with was saying that, which I think your brief very clearly argues, that the defendant didn't say anything incriminating in this conversation, and I'm not sure that that's tenable. That's a different question from whether there was the functional equivalence of interrogation. So the question that's hard here is, if a defendant is saying things sua sponte that are incriminating, what does an officer have to do? And we have there are cases where the officer, officers say, all different kinds of officers say very clearly, I cannot talk to you. I cannot talk to you right now. And Frost starts off in that vein and says, we can't talk now, we can't talk now. But then he digresses from that path. And the question is, where's the line?
And I want to be crystal clear. I agree that in an ideal world, there wouldn't have been these additional pieces of information provided. It would just be, no, he's not been arrested, and maybe he says nothing in response to, I can't believe Adam would turn state. I certainly agree that that would be a much better position for the Commonwealth. But the point I was trying to make to Your Honor, and I guess it's the incriminating nature of the statements is a little beside the point in the argument I'm trying to make, is I think the closest you get to functional equivalent of interrogation, which incriminating statements have to follow that, is the piece of information that we have a recorded interview of Adam Bradley. So like, you can see this interview and see what he said against you, if you're interpreting it in a light that's favorable to my brother. He's already made all his statements at the time Detective Lieutenant Frost says that to him, right? He's already said, did Adam turn state, and I can't believe Adam would turn state. So those statements have been made already. So if the provision of the piece of information that he's got a recorded interview is the point at which this turns into the functional equivalence of interrogation, and now we're looking at, okay, well, what did the defendant say in response to that? He didn't say anything in response to that.
In response to that, he agreed to be interviewed, and then he said a whole lot. So I think that it's a little of a novel argument, but they're saying you were enticed to go into the interrogation room, and I think that's the argument.
I'm sorry, I didn't mean to cut you off. Again, I think this brings the Commonwealth back to the first point we tried to make, which is that's not the test. The test is not, did the defendant agree to be interviewed because he wanted to see the video. Again, we could have confronted him with like, hey, Adam Bradley threw you under the bus. He said X, Y, Z. I don't think that renders a Miranda waiver involuntary. This court has even said that false pieces of incriminating information that police provide to defendants doesn't necessarily render their statements involuntary. So how can truthfully telling them about some evidence you have against them, if that was the law, I mean, we would have to invalidate, I would argue, a lot of statements that defendants make. So the test for purposes of this analysis, if we're looking at the cat out of the bag and Larkin and all of this line of cases that my brother relies on, is did the defendant incriminate himself in his un-Mirandized statements based on interrogation or the functional equivalent? And then if he didn't, essentially, as I view the law, because we only have to satisfy either temporal nexus or cat out of the bag, we can still use his separate statement. Now, I agree that there's the separate question of voluntariness generally of Miranda and the statements themselves. But here, the motion judge finds he's no longer under the influence of anything. He's a veteran of the criminal justice process. He's been Mirandized by Detective Frost on 2 prior occasions, and he's admitted to a variety of other criminal conduct and to having been interviewed in the past regarding other crimes. The interview, if you look at it, is no one's raising their voice. The officers, before he waives Miranda, acknowledge that he has a lawyer, acknowledge that he can talk to his lawyer if he wants to, that if he wants to do that, they don't have to talk. So the cards are on the table. He only incriminates himself, and mind you, in a way that's very favorable to him, right? The defendant doesn't have a duress defense at trial if his statement doesn't come in without testifying. So the entire basis of his defense at trial is duress, and that comes from the self-serving statements he makes during the interview. But he doesn't make those statements that admittedly are also inculpatory to a degree until he sees the video after he waives Miranda. So it's observing this evidence that the Commonwealth has after he knowingly and voluntarily waives Miranda, I would submit, that leads him to inculpate himself, not what happened in the Sally Port. And that's what you have to ask yourself is what happened in the Sally Port, is anything he did in the Sally Port to incriminate himself, is that what caused him to waive Miranda? Did he feel so defeated, like the jig was up? I have to give it up now because, there's no point in resisting. As the motion judge recognized, he just didn't know what the Commonwealth knew. I guess he can intuit that maybe they know some things because Adam Bradley's been interviewed, but he just doesn't know what information they have. So to suggest that that rendered him so incapable of resisting that he couldn't knowingly and voluntarily waive Miranda, I would submit is not supported by our case law in any way, shape, or form. And again, I would just reiterate in Larkin, again, they also assessed voluntariness of the Miranda waiver in addition to the cat out of the bag analysis. And the fact that the police had told the defendant that they had unimpeachable evidence of his guilt didn't cause the court in Larkin to find that the Miranda waiver and subsequent statements were involuntary. So again, I don't see how that could here. I think this case is largely controlled by that case. I'm happy to answer more questions on this first issue or either the jury instruction or 33E. If this court doesn't have any additional questions, the Commonwealth will ask that you affirm the defendant's convictions and rest on its brief.